So friends, earlier today, I was in the federal courthouse in Alexandria, Virginia, watching the motions hearings in the vindictive prosecutions of James Comey and Letitia James. And friends, based on the questions being posed by the judge, not so much to the defense attorneys for James Comey and Letitia James, but for this prosecutor that Lindsey Halligan brought into the case to argue these motions, based on Judge Curry's questions, it didn't go so good for Lindsey Halligan, or by extension, Pam Bondi, or Donald Trump's Department of Justice, for that matter. So friends, the first clip I want to play is a short video that I made outside the Alexandria courthouse right before the hearing started. And then we're going to talk about how the hearing played out and a couple of pretty surprising things Judge Curry said. So let's talk about that, because justice matters. Good morning, everyone. Glenn Kirshner here. So I'm here outside the federal courthouse in Alexandria, Virginia, preparing to attend the motions hearing in the Letitia James and James Comey cases. Interestingly, the cases have been consolidated for the judge to hear this argument today. It will be interesting to see both the former director of the FBI and the current New York State Attorney General sitting in a courtroom virtually shoulder to shoulder, arguing that their cases should be dismissed due to the alleged unlawful appointment of U.S. Attorney Lindsey Halligan. There is a smattering of media out here. I'll circle around so you can see. Certainly not the kind of media presence that we had at James Comey's preliminary hearing, which was held in this courthouse, or Letitia James, not preliminary hearing, arraignment hearing. And that one was held down in Norfolk. I attended both live, and there was a much heavier media presence at each of those arraignment hearings. But, today's hearing will be really interesting, especially because very similar issues have already been litigated and resolved by other federal courts, one in New Jersey and one in California. You may recall that a court ruled in New Jersey that Donald Trump's U.S. attorney up there, Elena Haba, was unlawfully appointed to that position. And it was just 2 weeks ago when a federal judge out in California ruled that Trump's U.S. attorney out there, a guy named Bill Assaili, who Trump made the U.S. attorney for the Middle District of California, was illegally appointed. And here's the most interesting part of that ruling. The judge said that he would not dismiss the indictments that unlawfully appointed U.S. attorney Bill Assaili signed because there were other qualified, lawfully serving and acting federal prosecutors who also signed those indictments. Well, guess what, friends? On the indictments of James Comey and Letitia James, the only prosecutor whose name appears on those indictments is, you guessed it, Lindsey Halligan. So, and let me just take on the question of precedent for a minute, because some people have asked, well, if this issue has already been resolved by other federal courts, doesn't that serve as precedent to help the judge resolve the issue in this case? The answer is kind of yes and no. It's not legal precedent, because what a trial court does in another federal jurisdiction doesn't necessarily apply and certainly doesn't bind how the judge in this case, in this jurisdiction, resolves the issue. However, it's something that I often refer to as atmospheric precedent. Judge Curry, who will be sitting by designation to hear today's arguments, Judge Curry is a federal judge down in the District of South Carolina, but because this issue involves the potential disqualification of a U.S. attorney here in the Eastern District of Virginia. Judges up here, Eastern District of Virginia judges, are conflicted out because they are seeing cases day in and day out that are brought by the Eastern District of Virginia U.S. Attorney's Office. So Judge Curry came up from South Carolina. She will be presiding over today's hearing and resolving this issue. And Judge Curry will almost certainly look to the opinions of the judges in New Jersey and California on the disqualification issue to decide if perhaps they are persuasive and she should apply the same reasoning in resolving this issue. So it's a little windy out here, the camera's a little shaky, but I'm going to head into the courthouse and I will update you on how the hearing plays out as soon as it's over. Okay, friends, now let's talk about what happened inside that courtroom today. Let's start with the new reporting, and then I'm going to do my best to translate all the legalese into English and then highlight a couple of the most important takeaways based on what I saw and based on what Judge Curry said. But let's start with this new reporting from NBC News. Headline: Judge appears skeptical of DOJ arguments for keeping Lindsey Halligan as prosecutor in James Comey and Letitia James cases. Attorneys for Comey and James argued that Halligan is unlawfully serving as acting U.S. attorney, and therefore the indictments against the pair should be thrown out. And that article begins, a Justice Department lawyer on Thursday defended the legality of Lindsey Halligan's appointment as acting U.S. attorney to a skeptical federal judge who's weighing whether to dismiss cases she, Halligan, brought against former FBI Director James Comey and New York Attorney General Letitia James. U.S. District Judge Cameron Curry did not issue a ruling after the hour-plus-long hearing, but said she plans to issue a decision by Thanksgiving on whether to disqualify Halligan from her post. An attorney for the Justice Department, Henry Whitaker, and friends, if I can interject here, Henry Whitaker is not some long-time federal prosecutor from the Eastern District of Virginia U.S. Attorney's Office or any U.S. Attorney's Office. He used to be Solicitor General down in Florida, and he's somebody that Donald Trump brought to the Department of Justice in, I believe, January of this year, and now he's some kind of special counsel to Attorney General Pam Bondi, who was just brought into this case this month. All my editorial edition. An attorney for the Justice Department, Henry Whitaker, characterized questions about the appointment of Halligan, a Trump ally with no prosecutorial experience, as a paperwork error. Halligan presented the case against Comey and James to grand juries on her own and was the only person to sign off on their indictments. Lawyers for Comey and James contended that because her appointment was unlawful, she was essentially a private citizen at the time, and the indictments against them should be tossed. This quote from Comey's lawyer, quote, when the only person presenting to the grand jury lacks government authority, it's a fundamental error, Comey attorney Ephraim McDowell told the judge. Halligan, who, of course, was part of Trump's legal team in the Mar-a-Lago classified documents case, criminal case, prosecution, was sworn in as interim U.S. attorney in one of the nation's busiest federal court districts on September 22nd. That's 3 days after Eric Siebert, the U.S. attorney who had been serving in that role since January 21st, resigned after being pressured to indict Comey and James. According to federal statute, individuals may only serve for 120 days after being appointed U.S. attorney, and Eric Siebert had served 120 days, unless confirmed by the U.S. Senate before then. The Senate had not confirmed him, Siebert, but district judges of the Eastern District of Virginia exercised their own independent appointment authority to legally retain Siebert as an interim U.S. attorney beyond the 120-day limit. It is that 120-day limit that James and Comey's attorneys argue should not start back at zero with the appointment of Halligan. James attorney Abby Lowell told the judge the 120-day period is designed to give a new president leeway for a limited period of time to get the office moving. In a court filing, Comey attorney Patrick Fitzgerald wrote, "If the Attorney General could make back-to-back sequential appointments of interim U.S. attorneys, the 120-day period would be rendered meaningless, and the Attorney General could indefinitely evade the alternate procedures that Congress mandated." Okay, friends, now please just give me a minute to try to translate that from legalese into English, boil it down to its essence, and expose this shell game that Donald Trump and Pam Bondi are trying to play, but it's a game that it looks like Judge Curry will not let them get away with. So here is kind of the way the law works. I'm not going to talk about the statute citations or the names of the different laws involved, but when a president wants to appoint a U.S. attorney, all three branches of government actually have a role to play potentially in that process. Here's how. The president names an interim U.S. attorney or nominates somebody to be the permanent U.S. attorney. But what happens after the president nominates somebody? The legislative branch, the Senate, gets to provide advice and consent. The Appointments Clause of the Constitution requires that. So the executive branch names a nominee. The Senate has a hearing, right, gives the nominee an up or down vote. At least that's what's supposed to happen in accordance with the Advice and Consent Clause. But there are a couple of wrinkles in this. If it's dragging on and the Senate isn't holding a hearing or the vote is delayed, an attorney general can name an interim U.S. attorney, but that interim U.S. attorney can only serve for 120 days. So what happened here? The president wanted to appoint Eric Siebert, longtime federal prosecutor in that Virginia U.S. attorney's office, as the U.S. attorney, and he was also named as the interim U.S. attorney. What did that mean? He had 120 days while the Senate was, putting together its confirmation hearing, and that 120 days ran out. And by law, an interim U.S. attorney only gets 120 days. And then the third branch of government comes in. I know this sounds a little bit complicated, maybe even Byzantine, but stick with me here. So we have the executive branch, the president, who nominates, or the attorney general who names an interim U.S. attorney. Then you have to wait for a Senate confirmation hearing. But if the 120 days runs out, that's set by statute, then it shifts over to the judicial branch. And the law that Congress enacted provides that the judges in that district, the Eastern District of Virginia, get to vote on whether they want Eric Siebert, that U.S. attorney, interim U.S. attorney, whose 120-day term expired, whether the judges believe he's an appropriate person to continue in that job beyond the 120 days until Congress gets around to holding his nomination hearing. The Senate gives their advice and consent, and they vote him up or down. So that's how all three branches of government are actually involved in this 120-day, statutory deadline. Everybody has a piece to play. Here is what Pam Bondi and Donald Trump tried to do. After the 120 days expired, and what happened? Donald Trump sent out a missive saying, I want people like James Comey and Letitia James and others prosecuted, damn it. He posted something directing that they be prosecuted. And Eric Siebert, good, long-time federal prosecutor, well-regarded, who had served his 120 days, said, I'm not doing it because we don't have the evidence. So, of course, he was pressured to leave. He either resigned or he was fired. And then what did Pam Bondi do? She tried to appoint Lindsey Halligan for another 120 days. Well, guess what? You don't get to, repeatedly appoint interim U.S. attorneys for 120 days at a time. Why? Because then you have usurped the function of Congress to provide an advice and consent hearing on a presidential nominee, and you have also usurped, stolen from the judiciary their lawful authority to name an interim U.S. attorney of their choice after 120 days. So basically what was argued in court by the defense attorneys for James Comey and Letitia James is, wait a minute. If we go with what these prosecutors, Lindsey Halligan and Henry Whitaker, are trying to peddle to you, Judge, do you realize there could potentially never be another advice and consent hearing in the Senate on a U.S. attorney? Because all they would have to do is appoint one of their flunkies for 120 days, then appoint a different flunky for the next 120 days, and then a third flunky. And believe me, Trump and Bondi have an endless supply of flunkies, it seems. And the argument was made for a president's 4-year term, or in the event of 2 terms, 8 years, there would never necessarily have to be an advice and consent hearing because they could just keep the revolving door of 120-day flunkies flowing for 4 years or 8 years. That's contrary to the law, the Federal Vacancies Act, and you can't do it. So friends, basically, that's what this motions hearing was all about. Does Pam Bondi, does the Department of Justice have to comply with the law, or do they get to cut out the other 2 co-equal branches of government, each of which has a lawful role to play in this process, the legislative branch and the judicial branch? Can they just cut them out, run roughshod over them by appointing a never-ending stream of 120-day Trump flunkies? I have a feeling Judge Curry is going to rule that no, they don't get to do it. So what are the next steps? First of all, Judge Curry said that she would issue her ruling before Thanksgiving, so we should expect it in the next several days. But let me end with this, friends, because this was a surprise, I think, to everybody in the courtroom. The judge said that it looks like there might be a missing grand jury tape. Here's what she said. She said, I have all of the grand jury materials, the transcripts, the audio tapes. And mind you, there are audio recordings made of every single word that is uttered in the grand jury, every word uttered by a witness, every word uttered by the prosecutor, every word uttered by the grand jurors. The grand jurors get to ask questions of the witness along with the prosecutor because it is the grand jury's investigation. But the court had requested all of the transcripts and the audio recordings, and the judge all of a sudden just kind of dropped this bomb in the middle of the hearing. Judge Curry indicated she's missing some of the audio recordings beginning at 4:28 p.m. until the grand jury returned the indictment. It sounds like Lindsey Halligan may have been talking to the grand jury, providing them information or arguments, and no record of it was provided to Judge Curry. And given that Judge Curry indicated that she could tell from the grand jury materials she was provided that Lindsey Halligan was the only prosecutor in the grand jury room at the time, this is going to become important. And it's always hard to read the tea leaves based on the questions that a judge poses to the parties, to the prosecution, and to the defense. But I didn't hear Judge Curry ask a single critical question of either the attorneys for James Comey or the attorneys for Letitia James. But when she was asking questions of the prosecutor, it was kind of along the lines of, well, how do you explain the following? Or, isn't your argument really inconsistent with, or what about this other precedent? There were quite a few probing, and I would say even critical questions of the prosecution. And if I had to read the tea leaves, I think there's a very good chance that this case may end up being resolved in the coming weeks, with the case being dismissed against both James Comey and Letitia James. Because, justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.